Hello, and welcome to another TDW Tech Bite. This is another in our data transfer series. Today we're going to look at the protection of personal data by contractual means in respect of data transfers. We're going to look at three particular points. Firstly, the legal environment that applies in the context of international data transfers from Hong Kong. Secondly, we're going to look at the recommended model clauses that have been published by the Privacy Commissioner for Personal Data here in Hong Kong. And thirdly, we're going to look at some other means that are non-contractual means that are often used for the protection of personal data to data processors. So let's move ahead with the first of those. As you may be aware from our previous talks in this series, there is no express restriction on international data transfers from Hong Kong. Instead, the regulation of personal data occurs through regulation primarily on the data user. Now, the data user is the equivalent in Hong Kong to what is sometimes elsewhere referred to as a data controller. It's basically a person or entity that controls the data lifecycle. There are two relevant data protection principles that apply to the regulation that indirectly applies to data processors. Firstly, in respect of data retention, there is a requirement that data processors should not hold on to personal data for longer than is necessary to perform the agreed data processing activities. Now, this is a data protection principle that the data user must ensure is complied with. There's also a data protection principle that applies to data processors in relation to security and the prevention of unauthorized access, loss, or destruction of personal data. Additionally, there's this extension of liability so that a data user in Hong Kong is responsible for the acts of his agents, which includes data processors, and wherever they may be. So you can see from that the primary target of the legislative regime is upon the data user, but the onus is placed on the data user to regulate the activities of data processors. Moving forward from there, how is this protection enshrined in respect of the implementation of these principles? Well, firstly, you have to understand that the transfer of personal data is in itself a form of use of personal data. So in the first instance, a data user in his personal information collection statement should disclose the parties to whom personal data is being transferred and the purposes for that data transfer. And that applies whether the transfer is occurring within Hong Kong or outside of Hong Kong. You will often find also a statement in the PICs that if personal data is being transferred to places outside Hong Kong, that it may carry a risk that it is in a jurisdiction that carries lower or less protections than may apply to personal data protection in Hong Kong. This is a way of notifying data subjects in respect of certain risks in relation to their personal data at the point of collection. Beyond that, there's a strong encouragement from the PCPD in Hong Kong that data users should seek to protect personal data through what is described as contractual means or otherwise. Now that means in respect of a transfer of personal data to data processors that there should be in place a series of clauses that are intended and designed to protect personal data to the same standards as would apply in Hong Kong. This can either be done in a data processing agreement or more commonly nowadays in a schedule to a main agreement that deals specifically with personal data protection. The PCPD has helpfully published a series of recommended model clauses that can be incorporated into contracts for this purpose. The clauses are in two sets. One for a situation where personal data is being transferred from a data user to a data processor. In other words, that the data processor will only use the personal data for purposes that are prescribed and in manner that is prescribed by the data user. The data user is controlling the activities. And a second set of clauses that applies in relation to the transfer between a data user and another data user, meaning the second data user can also use the personal data for his own purposes. These clauses are not mandatory, but they are strongly recommended. What that means is, if an issue arises, a data user that has used these clauses would be able to point to that fact as a means of explaining and supporting that they took reasonable measures to protect the personal data in question. Also, the clauses have been designed in a way that should be amenable to small and medium-sized enterprises using them. These are not complex clauses for complex contracts. They are relatively straightforward and clear provisions that can be adopted by many businesses. That said, the PCPD has also stated that it is not a requirement that the clauses be used verbatim. Now, this is unlike the position under the regime in the European Economic Area under GDPR, where the standard contractual clauses must be used without change. They can be supplemented with better protection, but they cannot be varied to produce lower protection. The PCPD has recognized that there's a commercial negotiation that goes on in relation to data processing agreements or data sharing agreements, and there may be some need for compromise, at least in respect of some minor aspects of the clauses. Now, this is something that will have a high degree of nuance, because the closer the provisions in contracts are in substance to what the PCPD has recommended, the more likely that the PCPD will respect and regard favorably the adoption of the clauses if an issue arises in the future. There are some odd features in relation to the model clauses. One in particular is a requirement and undertaking from the data processor that the personal data that it has received is no more than is necessary and is not excessive in connection with the data processing activities that it's being contracted to perform. Now, the reason this is unusual is that it is normally the data user that prescribes the personal data that is being transferred, and the data processor receives and adopts and processes that data in accordance with the contract. So it's unusual that the data processor is under this express obligation. That said, these are well-drafted clauses that should be considered in each case where a data processing agreement or schedule is being considered, or in the context of a data sharing arrangement between data users. There are other means that data users can adopt to supplement contractual means. These are measures such as audit and inspection rights, the requirement for data processors to apply for and obtain and maintain certain security certifications, and also notification obligations in respect of any incidents that might arise, including any breaches or data loss. And that broadly summarizes the legal environment for data transfers that applies in Hong Kong.